anybody on this side get a UCC 1 financing statement? I seem to have more here
Oh,
than I should.
sorry.
No, that's all right. Everybody should have two documents, a copy of a security agreement and a financing statement. I think these will be helpful in today's discussion. I've posted the full versions of these in the week 4 material, so you can find electronic copies of these. The UCC 1 that you have there is the Kentucky version, which is more or less the default. It's the same as everybody else's, I think, most states. So, what we're learning today should apply without any exception to stuff things you might be able to see. Okay, so for today, we're working on 2 parts of the reading. The first part we're going to talk about is the description. The second part is the attachment. Thank you. Anybody need a security agreement? Security agreement. I got 2 of them here. Are there extra copies? I printed 33. I think there's only 31 people in the class.
And then I need that. I need the
And another financing statement. Are there extra copies of the financing statement? Thanks. Yeah. Make sure you get one. Okay, cool. All right. So on the so just in terms of description, so we have 2 documents that both have a description. So let's take a look at the security agreement, okay? If you look at the security agreement document, who can quickly find in here where the description of collateral is? All right? Definition, okay. And how does this agreement provide for a description of the collateral? Yeah, it's got it as an attachment, right? It says Exhibit A. So this form is set up to be sort of generic, and the specific description of collateral will be contained in a document attached to this agreement called Exhibit A. So hopefully when it's complete, you will see a list attached. And it's whatever's on that list, okay? Where on the financing statement do we have the description of collateral? That's this document. Sorry? Section 4, yes, towards the bottom, where it says, this financing statement covers the following collateral. Okay. So you can see, very different sort of setup. The security agreement is a contract. There's nothing magical about that, the way that contract's drafted. You can draft it however you want. You don't even have to call it a security agreement, right? You can include in the text of the document, I hereby grant you a security interest in my truck. You can say that. You don't need to have it as an exhibit. That's just how this bank set it up. So there's no magic to it. There is magic to this, because it's a form. This is what the Secretary of State's office will accept for filing. And in fact, this form probably is not what you will file. You will file it electronically. You will fill it out electronically. But this is the document. Handy, on the back. What's on the back? Instructions. Unlike the security agreement, which is a contract which allows complete, more or less freedom of contract. You can write whatever you want. If you follow the instructions, you can't screw this up. And yet people do. But not you. Whose class are you in? You're in my class. So when you leave this class and you get this document, you're going to remember, oh my gosh, I will not screw this up, because Professor Smith will come to my employer and berate me and yell at me in front of my coworkers. I don't care. All right. But if I say stupid stuff like that, maybe you'll think about it when you're in business, filling these things out. Because I do get people who call me like 10 years later. I just fell out of UCC 1, Professor Smith. Whatever it takes. Okay, so for the first part of this class, we're talking about what goes in here and what would go on Exhibit A in the security agreement. Are these the same thing? Is the financing statement the same as the security agreement? No, they are two different documents. What's the purpose of a security agreement?
To between the buyer and the seller, or not buyer and seller, but the borrower and the lender.
Yeah, more or less, yeah.
Yeah.
Secured party and debtor is how
Yeah.
is the language we use in this class, but that's exactly right. And it could be a buyer and a seller. That's actually not wrong. That's could be a kind of security agreement. That's a contract between two parties. Is this a contract? Not a contract. What lazy, malpracticing attorneys do when they screw this up is sometimes they say, oh, please accept my financing statement as the security agreement. What's missing on this form?
Signature?
Right. The document I printed out for you, the 2-pager, is actually a 5-page document. So I printed page 1 and page 5. What's page 5 of the security agreement have on it? You know what? Yeah, the other. Oh, it should be two-sided. Did you only have a single-sided document? Incompetence, once again, rears its ugly head. I said 1,5 when I went to print, but I didn't check it. On page 5, fortunately I did bring a full copy of this. It should look like this. And it does look like this on your, you do have, so some of them did and some of them did. Okay. A financing statement does not have this. What is this? It's the signature page, or in the language of Article 9, it's an authentication document, right? Authentication, but it includes signature, okay? Financing statement does not have this. It used to. And so the argument that the financing statement could be a security agreement actually worked in some cases. But they changed the rule. You don't need a signature on the financing statement anymore, so therefore it can't be a security agreement because there's no authentication. At least there wouldn't be because it's an electronic form and there's no spot to type in signatures, okay? I emphasize this because I think one of the confusing things here is the purpose of the description. On this document, what's the purpose? What's the purpose in the financing statement? Exactly, it's a notice purpose. So its accuracy is less important than its notice function. What's the purpose of the description in the security agreement?
To make sure you have your collateral if they don't pay.
It's a contract, so we need to make sure that the description covers the collateral that's described, right? So you're actually creating legal rights in the security agreement. You're not in the financing statement, you're providing notice. In the security agreement, you're creating a contract that covers the collateral. You can have a financing statement, and we have a problem on this, but I just want to say it now before we get into the problems. You can have a financing statement that says more things than the security agreement. What creates the security interest? What document creates the security interest? The agreement, right? The contract that the parties sign where the debtor grants. Look at the security agreement debtor under definitions, section 2. I grant you a security interest. That's the language that the court is looking for. That language is the language that creates the security interest, okay? If you have a statement of collateral, sorry, I have the wrong document. If you have a statement of collateral on this document, let's just take an easy example. This document says inventory and equipment. This document on Exhibit A says equipment. Is there a security interest in inventory? There's nothing wrong with that document. It's perfectly fine. As filed, broader than the contract, doesn't destroy anything in here. There's no security interest. You didn't contract with the secured party as a debtor to grant the security interest. You didn't, by contract, grant the security interest in the security agreement. They can't foreclose because you didn't give them the right to do it. The contract is between the secured party and the debtor. All rights of foreclosure flow from that. This creates no rights except notice. So it can be broader. It can be broader and not have, as long as it covers the stuff that's in here, you're perfected. All right, now I have mentioned this before. You want to be perfected. Okay, and as a law student, your goal is always to be perfect. It is the secured party's goal to be perfect. You don't know what it means to be perfect yet, and you don't know yet what the effect of perfection is. This is the first step. Being perfect requires the documents to be right. So today, we're going to talk about description and attachment. That's where we're talking about getting the documents right. Next week, we're going to talk about the methods of perfection, how you become perfected. And then after that, we're going to talk about, in the priority battles, the consequences of being perfected. But in the back of your mind today, you don't need to fully understand what being perfect means. You just need to know that the documents need to be filled out correctly for that to happen. That's the first step. With that in mind, any questions about the lectures, about the reading, about, before we get to the problems, anything? There are 2 assignments for this week. I didn't have as many lectures. I had an extra Cali assignment. They're not due until tomorrow at midnight. So if you've done them, great. You'll really get a lot out of class today. If you didn't, you still have until tomorrow at midnight to do the problems, and maybe reading the material, hearing it in class, and then doing the problems. It will click. And if it doesn't, post a question, come talk to me, whatever, okay? We're starting to really get into the stuff this is now starting to get complicated. And this is where people get tripped up. And the reason I want you to have the 2 pieces of paper is, as we go through the problems, the question is going to be, which document are we talking about? And what's the effect of the problem, on the documents on the answer to the problem, okay? Good, all right. Problem 25. I have a list of people I already called on, right? Do you like when I just went around the room? Was that just easier for you guys? Did you like that? Yes? But because I'll randomly start somewhere so you won't know where we're going to go, but then you'll see where we're going.
Going around the room is cool.
We already went through once, right? And then we started back over here, which I said was unfair to you guys, so I'm going to go over here. Miss Nicole, do I have it right?
Yeah.
Should we work through problem 25?
I think we're on 32.
Yeah.
Oh, 32, sorry. 32, thank you. I got so excited. Yeah, we're talking about description. On page 90, what page? 86. 32, thank you.
I said the guitar isn't affected, or isn't covered under 9108 because it's not specific to the item. And then I said under 9504 it is protected.
Okay, so we have we have a security agreement that says all personal property debtor now owns or ever hopes to own between now and the end of the world or his death, whichever occurs first. So, describe again, under which document are you talking?
Under the security agreement, under 9108, I said that all assets is like, that description isn't permitted.
Correct. Okay. So that's perfect. You're not perfect, right? They're unperfected because they have a faulty description of collateral because the all assets type of description is not legal, 9108E, right? Is it okay for the financing statement?
Yes.
Okay. All assets works for the financing statement. Why would that be?
Because that's what it said in the lecture.
That is exactly correct answer. Don't know why, don't care. No. So from a policy perspective, financing statement is about notice, but it requires additional investigation, right? It doesn't create the security interest, it says it might exist. So the security interest in all assets means that there might be a security interest that covers everything, but it doesn't mean that there is. The way we know that there is the security agreement. So you always have, the other people out there who are searching have to ask another question. I'm less concerned about the full policy reasons behind stuff. I think it helps when you are arguing to a court to know why the drafters did something. But for getting the answer correct, the answer is clear. 9-108, not permitted. It's illegal. For any debtor, not just consumers. You cannot say all assets in the security agreement for any debtor. This seemed more like a consumer case. Questions about that? Straightforward? Everybody feel good about that? Okay, good. All right, the Grabowski case, again, these cases are not there to explain the law or to give us the law. They're there to give examples of how the statute gets applied. Let me just quickly say, is the word equipment adequate to describe equipment? The equipment in the case, the John Deere 4630 tractor, for example. The court says yes, right? It's not at the person's address, right? Is that okay? Yeah, we don't care where it is. You can describe, in the security agreement, you can describe collateral by the type of collateral listed in the UCC definition section. And that is considered adequate. And even if you only have one piece of equipment, it would cover it. If you have 100 pieces of equipment, it would cover all of it. And that's what the case is saying. Describing the collateral simply by category is acceptable, and this is an example of a case where the court's going, doesn't matter where it was. Don't care what the address is. Does not matter. Now, let me flip this a little bit. What if the description of collateral in the security agreement said, all equipment located at 100 Main Street? Does the address matter then? Yes. You can narrow your definition, your descriptions, but if you use a broad category, it covers everything. So if you say all equipment at 100 Main Street, would that include stuff at 101 Main Street? Nope. And we may not know what's at 100 Main Street. We might have to ask more questions, but we know for a fact that anything at 101 Main Street, not covered. So you can be very specific if you choose to. They chose not to. We used a broad category. Don't care where it's located. All right. So 33. So Nathan?
Okay, so I said that just based on the Baker case that's listed, the financing statement, you would sufficiently describe the 20,000, basically just because the names are a sufficient identification of the collateral.
I did not grow up in the country. I don't know anything about farming. I used to teach property. I will teach it next semester. There's a case in the casebook about a hay rake. I was like, hay rake, like this big? No, hay rake is this enormous piece of equipment, right? I don't know anything about this. I had no idea that they drew pictures of cows for identification purposes and gave them names. But in this industry, why is this description acceptable?
It says, well, the case basically said that that was a valid way to identify each cow rather than just the ear tags.
And do people in this industry know that the ear tags fall off?
Yes.
Okay, what's the purpose of the financing statement? Notice, do people have noticed that some cow on this farm might have a security interest?
Yeah.
How many financing statements were filed in this case?
Like in the case, like the Baker case, or the problem?
In the case.
Oh, I'm not sure.
Well, in the problem, how did they do the financing statements? Because it's based on the case. I think this is really what I think distinguishes this case. There's a separate financing statement for every cow. Isn't that what the problem says? Every time there's a security interest created in a cow, they file a financing statement. Okay? They try to put the tag number on it, but they name the cow right? What does it say is on the financing statement?
The name, the ear tag, identification number, and a description of the plot sketch of the cow.
A new financing statement, it seems like, for every cow. Could you find that cow with that financing statement?
Yeah.
Anybody ever gonna be confused by that financing statement? No, right? It doesn't have to be perfect, it has to provide reasonable notice to other lenders. And I think the fact that it's a separate financing statement for every cow, that's critical. Another way to have done it would have been see attached, right? I think with the financing statement, you can add additional documents. Where do you click on that? It might be under the optional, oh, it's on the instructions. The instructions say, yes, use item 4 to indicate collateral. If space in item 4 is insufficient, put the entire collateral description or continuation of the collateral description on either addendum, form UCC 1AD, or other attached additional pages. So they could have had that also as a list. Cal, Bessie, Fred, I don't know what those people call it. Okay, great. Industry standards, it's okay, it serves its purpose. You can get to this cow and find it. And that's purpose served, right? Again, document we're looking at, this document, not the security. All right.
So the Murphy case says that the credit card receipts are good enough because you can identify the goods using them, but Cunningham said that because that the records were not part of the security agreement, it would not be sufficient. And I would kind of lean towards the Cunningham case because when it says that the security interest in all goods purchased on your account, I don't think that would be sufficient to describe specifically law books that you purchased with the car.
Yeah. Anybody ever purchased something on with a credit card at Best Buy? How long is their receipt? It's enormous. If you were a credit card company, if you're Best Buy, what I would do is I would say, the security agreement covers everything listed on this receipt, and then have the consumer sign the bottom of the receipt, right? And then you have a security agreement. I would just make every receipt a security agreement. That's certainly technologically feasible. What they're suggesting here is the only description of collateral is in the agreement with the credit card that says a purchase with this card covers the collateral purchased. And there are cases where the courts have said that's enough because you could just go get the receipts. Okay, that might be okay. Other courts have said no, that's too difficult. It's hard to walk into the house and know where the receipts are. I don't know what the right answer to this is. I personally think that if I'm going to choose between a consumer debtor, because that's usually who we're talking about, and a bank, I would go with the consumer debtor and say you needed a little bit more than a statement that anything purchased with this credit card is secured. And there's a technological way to do it, just on the receipt. Have them sign the receipt and have it say, I hereby grant a security interest in everything on this receipt. Easy. Okay. Any other thoughts? Does that make sense? What document are we talking about?
Security.
Okay. I just want to make sure we understand that. So the purpose of this question is to say, do we even have a security interest? And we do, or we don't, based on how the court reads that document. Yeah. It's not the financing statement. It's the security, or do we even have a security interest? And that's the security agreement. Okay? I don't want to move ahead until everybody looks at me and says, this is so obvious, why are you wasting my time on it? Is it obvious? No, I don't, I'm kidding. I don't, that was a joke. Yeah. There's no security interest if there's not an adequate description of the security agreement. So there's no security interest here if the credit card contract statement, every purchase is secured, is not sufficiently detailed enough. And one of the courts said, no, because
It was not specifically part of the security.
it was hard to really get at what was covered. Yeah. Fair enough. Me personally, I like that. I think that's a good decision because it, the purpose of what's the purpose of the security agreement? It's to create the security interest. If the debtor doesn't understand what they're doing, they don't know what they're creating security interest in, it feels kind of like a trick. And that's why I would side with the consumer. However, some courts have said otherwise. If this were a credit account like if Walmart had signed this agreement, would we feel bad for Walmart? Right? If Walmart's buying stuff from companies all the time, right? Just constantly. And for them, it would be a huge pain to always have to have a new security agreement for everything. One way is just to have inventory. If you just say inventory, you're cool. You don't need anything else. You just say inventory. Problem solved. But you can't just say consumer goods. So for consumers, it's harder. You have to actually specifically list the collateral, and that's the key issue here. Consumers cannot sign a security agreement that says security interest in all consumer goods. That's an exception.
Yeah, I was just gonna say that consumer goods and consumer transactions have like that heightened standard
Yeah.
for the description.
9108E, right?
Yeah, if this was an exam question, would you want us to walk through whether the law books like were consumer goods, and then that would lead to our analysis?
Yes. So if I, in a problem in a book, and I just say, Bob the lawyer, buy some law books.
Right.
If they're books for the business, they're probably equipment because they're not for sale and they last longer than, pens and paper. So they're equipment. But if it's, Bob likes to read about law on the side for personal pleasure, then it's consumer goods, and description can't be consumer goods. All right? I'm gonna go across the back today. All right. Thank you, Ben. I know you, and I don't have your name down here.
Kelsey, Mark,
How you doing?
should be on the thing somewhere.
Yeah.
Well, not expected to happen.
Oh, sorry.
That's fine. How long?
So we're on problem 34, right?
Oh, over.
Sorry, 35, right?
Yeah, what on? Yeah, so,
So first, what document are we talking about?
financing statement.
Okay. What part of the statute covers the description in a financing statement? So it's the financing statement. In order to know whether the security, the description is adequate, it's 950. Okay. It's the security agreement. What section? 9108. Okay. So, you read the description. Do you think that it's adequate in this case?
Well, I didn't know, so I looked at the case I cited, and the court seemed to say that the description is sufficient.
Was sufficient.
That's how I read it.
The description was sufficient.
I was skimming it in case you came over instead of going down, so I didn't have the original case, but I thought it was insufficient for what I read. And the case that was cited.
So,
I sit down and read the conclusion section of the case.
so what's the, let's take a look at the description, all right? So what's the first phrase on this financing statement?
All assets?
Okay, what does all assets mean? Trick question, what does all assets mean? It's not a trick question. What does all assets mean?
All assets.
All right, under 9504, can a financing statement say all assets?
Yes.
Yes! Super generic descriptions are okay in the financing statement. Why would that be? What's the purpose of the financing statement?
People on notice.
Notice. So since it says all assets, what's the notice that's provided? Hey, everything this person or company owns could be subject to, personal property, could be subject to a security interest. After the phrase all assets, what else does it say?
Including what I alluded to, a list of things,
included but not limited to. So what does that phrase mean, do you think?
They're listing things in particular, but also not waiving their right to claim other things not on the list.
I have used this phrase many times in documents I've written because I want to make sure that everyone's on the same page about something that I'm worried they're not going to understand, right? I say all assets, and then I get nervous. Do I need to be nervous? Legally. Do I need to be nervous about a statement that says all assets?
No.
I do not. But lawyers, anybody ever read their deed to their house? Know all men by these presents. I hereby grant, convey, sell, transfer, blah, 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 blah. Why is it written that way? Because we're risk averse. Exactly right. We're nervous. So if you're nervous, does including but not limited to limit the all assets description?
No, it does not.
I don't think it would, right? Cool. And that's not uncommon. You might see that in these kinds of security agreements. You say all assets including without limitation. Or not, all assets including but not limited to. Okay. So what's the issue and the problem?
It's related to the location, and then the business moves to a different location, no one ever updates the financial statements, and they want to see if the security interest is still valid or transferable.
Yeah, and what did you think the case stood for?
I think it said no. That they should have amended their financial statement and stay up to date. I was also curious about the own now and enter after acquired. That was in the agreement. And the interest, yeah, it also was interesting.
Okay. So this is a quote that I have from the case.
Well, you're probably going to have read more thoroughly than I did.
Initially, the phrase "and located at or relating to the operation of the premises" is included within rather than set off from the exhaustive list of collateral examples follows the phrase "including but not limited to." This court therefore disagrees with the plaintiff that this reference to location naturally modifies the phrase "all assets," inasmuch as an interpretation would require ignoring the "including but not limited to" language. So that's why I was focusing on that. The court was willing to accept, as drafted, the meaning of the words, right? It's not all assets, but only including. That would be different. This was including but not limited to. So the court was okay with it. And what's the purpose of a financing statement? Notice, not creation of the security interest. So if we're going to default anything, did it serve its notice purpose?
Yes, it did.
It did, right? Okay. Further inquiry from the parties concerned will be necessary to disclose the complete state of affairs, the court says. Okay? So it served its notice purpose. Okay. Would the all assets description have been acceptable in the security agreement?
No.
No. So now we have a problem. It's not asked in this question. If we have all assets, including but not limited to, in the security agreement, how do you think a court would interpret that? It's not asked in this question. I'm being unfair. I'm asking you to extend your analysis. Do you think the court would have thrown it out or would have limited it to the included but not limited to?
I'm going to extend the analysis class and ask.
What do you guys think? You're looking at a security agreement. Are you allowed to say all assets?
No. So
It says all assets. So what do you do?
throw it.
That language you throw out. Do you blue pencil it, which is an editorial concept where you just line it out and then ask, well, I've lined out the bad language. And then it says including but not limited to. Is that still okay?
Please apply it to this, as long as it's not.
I might just limit it to the things that are included, right? I think that probably works. I would be surprised by a court trying to deciding there is no security interest. I would expect that they would line out the language that's bad and see if you can read it in a way that is still valid. And it seems to me you could, right? You could say there is some collateral that's listed, and that's appropriate. Yes.
Take out the word all.
Yeah.
And then just leave it
Yeah,
like
that's what I'm saying with blue pencil. You strike out as much as you need to make it legal and see what's left over. And can you read it in a way that is adequate? And you think that you could?
Well, I'm asking you.
No, what do you think?
I mean, it would make sense. You said assets of the debtor, including.
It's not the question. I'm wondering how you would interpret it. If you were the judge, what would you say? You've crossed out the word all. How do you feel about the rest of the description?
It seems specific enough.
Yeah.
Yeah.
I think the court would go, we're cool with this additional collateral being, this specific collateral being included. Purpose served, right? The debtor clearly intended to create a security interest in at least the collateral that was specifically listed. They can't do it in all assets, that's illegal, but they can do it in specific collateral. So I think that's what I would say, yes.
So if they did move their business, would we have to amend the security agreement?
Okay, so we are going to, I know that's in this problem, but I'm not gonna worry about that for today, because that's something we're gonna talk about later, what happens when people move and stuff goes. Now, if it had said equipment, does it matter where it's located?
Well, they said at that property.
Right, but if it just says equipment, does it matter?
No.
If it says equipment at that property, does it matter?
Yes.
It does. At the time of the creation of the security interest, the collateral's at that location. Great, covered. Collateral moves to a new location. Does the security interest continue in the collateral after the relocation?
I hope.
Yeah, it usually does. The problem is when it goes out of state. Is it seriously misleading at the time when the property is moved? Do you remember from last class when we started talking about what happens if it becomes seriously misleading? Is it still good? Is the security interest still good?
For 4 months it is.
No.
Oh.
For existing collateral, it's still always good.
Yeah.
For collateral that is acquired more than 4 months later, it's no longer good, right? It's a new address, doesn't cover it. Balance it. Yeah.
So in that example, instead of, you know, equipment, it was specifically a tractor.
Yeah.
But then it also put a provision for any tractor to be bought down the road.
All right, so let's follow up. Yeah, so that's what is the after acquired property clause?
But any move, so that tractor that was already listed there specifically, it's
So-
not misleading for that one, but it could be misleading for stuff that was gotten in the future.
Now owned or hereafter acquired. Right, so that's the after acquired property clause. Is that clause valid?
Yes.
There's a problem in here, we haven't gotten to it yet, but let's jump ahead. What section makes this valid? Up to 9204A. But the after acquired property clause applies to collateral hereafter acquired located at 100 Main Street. It's located at 101 Main Street. Does the description cover it?
No.
So, well, it could be. It depends on how the description is written, right? For today, let's concentrate on, is the after acquired property clause still valid? Yeah. If we want to understand how the relocation, that was section 310, right? We did that last week? Wasn't it 310? No, where was it? Well, let me come back to that, okay? I'll find it in a minute. I want to make sure we get through everything, and then I'll come back to it at the end, okay? All right, so we all good? Everybody feel good about this? Yes?
I just have one, I mean, I know in this one it's referring to a financing statement.
Yeah.
Is it still, I mean, I still think that would be enough to create notice even if the address is wrong or.
Yeah, and I want to distinguish between the security agreement and the financing statement. That's why I want to move on, but I'm going to come back to it, okay? The question is where is this description included? Do you need an after acquired property clause in the financing statement? The answer is no. You need it in the security And there's a problem on it, so if we still don't understand, I'll come back, okay? All right, so that was problem 35, so 36.
This might go against everything you said, but this deals with.
I skipped over you? No, all right, I'm sorry. No, we're good, it's all good, I'm losing my mind, it's okay.
Yeah.
Yeah. That's exactly right, yes, problem 36.
Right, so this deals with a financing statement, and the Emory Boogie case said that that financing statement did not reflect the interest and the general intangibles in that case, because it was overly broad in describing personal property. And
It looks like a super generic, right? All assets. What does Article 9 cover? Security interest and personal property. So when you say personal property, it's essentially everything that Article 9 covers. It's essentially a super generic.
So this is what I don't get, because these cases say that the financing statement was overly broad in describing personal property and that it was too generic and that it gave no indication as to what property was being secured. And in this case, Polly pledged her jewelry. It wasn't part of the financing statement, and even if it was, does it fall under personal property?
So what year is the case that's cited here?
89 and 80.
When did the statute change? 2000. What does the new language say of the statute in 9504? Is a super generic okay in a financing
Yes.
statement?
Okay, so it does go against everything you said.
Well, it's not okay in the security agreement, but we're talking about the financing statement. Yeah. It used to be that the financing statement also had to indicate the collateral by type or something. The language was different. But now it's all assets is okay. I think these are old cases that probably would not be decided the same way today. So they cite them in the problem, but for the point of understanding, the law has changed. And the new law says super generics are okay. Is personal property too vague for a security agreement? I mean, for a financing statement?
No.
Is it for a security agreement?
Yes.
Yeah. So the question is, does it serve its notice purpose? Do you think it served its notice purpose?
I think so.
Yeah.
Yeah.
Personal property of any kind may be covered by this financing statement. Now, in this case, what happens? Doesn't she have the jewelry, right?
Yeah, she pledges her jewelry to the bank, and then she asks to borrow it, and while she's on her way to return it, another creditor sees it through a judicial process. So they're asking if the original security interest was enough.
Yeah.
Sorry, the initial
Financing statement was enough. So this is an example of the priority battles that come out of being perfected. If you're perfect, you win the priority battle. If you're unperfected, you lose it, probably. So that's the problem. All right, financing statement, the cases cited are old law. The new law is super generics are okay in financing statements. So for our class, essentially, the financing statement can say anything, but it has to say something. Can it be blank? No, which is sort of dumb. Why don't you just allow blank? But no, it has to say something, because that's the law, right? It has to have a description, but it can say all assets or all personal property or whatever. But it has to say something. It can't be blank. All right? Sure, yes, of course.
What is it with some stuff that can be perfected by possession or some, what am I thinking of?
Next week, you're thinking of. You're
So-
thinking, oh my gosh, I'm so excited about reading next week's assignment.
Yeah.
If you look at the next chapter, that's the first thing we're going to talk about next week is how you get a perfected security interest by possessing it and
So
what
that-
can be
they couldn't have
possessed.
said that about the jewelry.
So the jewelry was perfected by two methods, possession and filing.
Okay.
They gave the possession away. Did they lose their perfection by possession? Yes.
Yeah.
But if they still had a filed financing statement, they're still perfected.
Okay.
Yeah. You can have multiple methods of perfection. And as long as you have a backstop, you're okay. All right, thank you. Mitchell.
Yes. So this one, it talks about, they just list in the security and financing agreement, they list the collateral as inventory, and then ask, is this limited to inventory that they have now, or does it extend to the future? And based on the case that it cites, the Filter Corp, and that one, it was a little bit different, because the court found that it does not extend, or in that instance, it did not extend into inventory in the future, but that is also because they used relatively specific language describing the inventory that they had at the time, whereas here it just says inventory, but I still don't think inventory in this case, because there's that, when you have an avoided it hereafter required, I feel like in this instance, it wouldn't extend into the future, in either the security agreement or the financing statement, just the inventory.
So let's talk a little bit about what do you need an after acquired property clause? So which document are we talking about if we're asking, do you need an after acquired property clause?
Security agreement.
Okay, so it's the security agreement. It's the creation of the security interest. In the case, the description of inventory is very specific. So it sounds like existing inventory. Can you create a security interest in only the existing inventory? Of course, sure, whatever you want. The way I would probably expect the language to sound is say, all inventory now owned by the debtor. That's only the stuff owned now. So what's the deeper question? Do you need an after acquired property clause for inventory, for all inventory whenever purchased?
Because if you just put inventory and you intended when you were trying to get a security interest, or when you were, trying to get credit, and I just wanted to put the current inventory up as collateral for it, and then you come back down the road and take everything I've acquired in the future, that would be terrible for me as the consumer, or as the person borrowing.
So take a look at 9108, comment 3. It says, much litigation has arisen over whether a description in the security agreement is sufficient to include after acquired collateral if the agreement does not explicitly so provide. The question is one of contract interpretation and is not susceptible to a statutory rule other than a rule to the effect that it is a question of contract interpretation for particular reason. Accordingly, this section contains no reference to the descriptions of after acquired collateral. Does that provide an opening for descriptions of collateral that automatically include after acquired collateral? Okay, for our class, because this is also, I think, consistent with many cases. There are two kinds of collateral, when listed by type, normally include after acquired collateral: inventory and accounts. And that's a practical reason. There's a practical reason for that. If you're a store, your inventory is shifting day to day. Your inventory is never static, right? What your equipment can be a fairly static idea, but your inventory changes. The minute the store opens, your inventory changes. So knowing at any given time what the inventory is requires, like an audit, and you got to go check stuff. So the courts are comfortable with it including inventory whenever required because it's a shifting idea, okay? Same with accounts. The balance of accounts changes from minute to minute. As people make payments, their accounts go up and down. It's a shifting idea. However, there are cases like this where the court says we're not comfortable with after acquired inventory. They didn't say that. So you're a careful lawyer. How do you avoid the problem of that case if you want after acquired inventory?
I say inventory now or hereafter acquired.
Now owned or hereafter acquired. If you say that, does that include after acquired inventory? Yes. For our class, I'm going to say that these are two types of collateral as described in Article 9, that it is okay to assume they include after acquired collateral. However, I'm not advising you and I'm saying that because court cases have said that, not because I just, hey, whatever. Court cases have said, because of the nature of inventory and accounts and the way that they change over on a regular basis. My preference is that if you're covering after acquired collateral, you say it in explicit terms. All collateral now owned or hereafter acquired, or all inventory now owned or hereafter acquired, all accounts now owned or hereafter acquired. And if I don't want you to worry about this, I'm gonna put that in the that language in the contract. If I lose my mind and forget to put it in there, then you can say in an answer, inventory is the kind of collateral that many courts accept, can expand and contract over time, so it includes after acquired collateral. Every other form of collateral needs the phrase. So the default rule is you don't have after acquired collateral unless you have a statement to that effect. There was a question, someone had a hand up, I just want to make sure. Yes?
I did. I think you answered it. How does that relate to 9204? It says it's about after acquired property, future advances.
Yep.
And it says you may include that after acquired provision, but it doesn't apply to consumer goods.
Right, so consumer goods, you can never have after acquired consumer goods,
Okay.
that's accepted. But if you get, let's go back to 9108 comment 3. Take a look at 9108 comment 3. They punted. They didn't require it. They said the contract interpretation rules will apply. And I'm telling you that there are cases where the courts have said, because of the standard in this industry, the assumption is when you say accounts, you mean accounts whenever acquired. It just automatically includes it. Same with inventory. Okay? That's what I'm telling you, is that 9108 comment 3 allows a court to interpret this language to say it automatically includes after acquired. Every other form of collateral, you have to state it, and consumer goods cannot be included. So for every consumer good that's subject to a security interest, there has to be a statement by the debtor that they're granting a security interest in that collateral, in that consumer good. Yeah.
I'll just to both finish it up, try and finish up the problem, and then also ask a question.
Sure.
I'm assuming, so the next part of the question asks, if the security agreement says inventory now owned or after acquired, but the financing statement just says inventory, I feel like that would still protect the security interest in there, because the financing statement is just, again, the financing statement, as you said, is just for those.
So take a look at, I think, is it comment 2 to 9504? Am I looking at the right section? I believe in 9504, I forgot to highlight the phrase. I don't believe you need, so you don't need it in the financing statement because of the notice, right? It doesn't create the security interest, it just puts people on notice that it possibly exists. Cool. All right. That was 36, right?
That was 37.
37, thank you. So 38. We're almost done with the descriptions of collateral, and then we'll move on to the attachment. Okay, problem 38. Moving down over to Dylan.
Yeah. So this one's looking at the financing statement, and the description just said various equipment, see attached list, and then they didn't attach a list.
So which document are we talking about?
Financing statement.
And the financing statement has no addendum. So is there a adequate description of collateral?
Yes.
Why?
Well, it says various equipment, and you can, for a financing statement, you can say all assets. But then when I read the case, it said that this was insufficient because it didn't really put anyone on notice of what it was, because it was a little misleading and ambiguous, because there wasn't a list that listed.
And understand, many of these cases are bankruptcy cases, and who's challenging the description? The trustee in bankruptcy. The bankruptcy court is often quite sympathetic to the trustee, and so the trustee comes in and says, there was no list. How can I possibly know what's subject to the security interest? And the answer to that is, you're right, you can't possibly know. Was this an all equipment description?
Various.
It said various, so various suggests what? It's specific items. Did it include a description of any specific items? Would anybody be able to figure it out from that financing statement? Has the notice ever been served? Your analysis about, well, but the notice is served sort of, because we can have super generics.
Yeah.
Which do you prefer?
I mean, I would prefer if they just attach a list and have it.
Yeah, but if they, under the circumstances of the facts, do you think that that financing statement should be adequate.
I don't think so.
Here's the problem. The statute says you have to have a description. Does that include a description? It just says various. It doesn't say all, and it doesn't say which specific kinds. So if you're a court and you're reading things closely, is it legitimate for a court to say that's inadequate? Do you think?
I would think so, because we don't really describe any equipment as various.
If you're lucky, you get a judge that is sympathetic to your argument, well, but I could have said all equipment. It's at least an indication of notice that some collateral is covered. Let's go look at the security agreement. I think that that's a very good argument. But it often fails because it's the trustee in bankruptcy court that's making the argument. And who's the person that's making the argument? Oh, it's okay. Who's making that argument? Who's arguing this description is adequate?
Would it be the trustee?
No, the trustee is saying it's inadequate. Who's the person saying it's adequate?
Oh, yeah, that's your point.
And that's a bank.
Yeah.
Do people cry over banks losing security interest? No. My suggestion would be that you could convince a judge maybe that this is adequate, given the purpose of the notice filing, but a judge could read it very literally and say the statute says you have to have a description, this does not have a description, sorry, you lose. But I think the better answer is assume you're gonna lose, and maybe you'll get lucky and you get a good judge. But I think personally it's inadequate, and I think the trustee will win this 99 times out of 100. Okay. As between two banks, I'm not sure. So if it's a fight between First National Bank and Second National Bank, who cares? Some bank's gonna win. It's adequate. But if it's the trustee who's supporting the unsecured creditors and it's in bankruptcy court, then I think a bankruptcy judge sides with the trustee.
So, sort of in this vein, say it doesn't, there's a financing statement, it doesn't say various equipment, it doesn't say all equipment, it just says equipment. Would that be sufficient?
So it just says equipment. Well, you tell me, what do you think?
Well, I think that if you're looking at Article 9, that's the category, so that should be fine. But if you just say equipment, it seems like the same as saying various equipment, so I was just curious.
Yeah, I agree with you. The problem is it says various equipment as described on the list. That's the part that screws us up. If you had just said equipment, are you okay?
I mean, I guess.
No, don't guess. Tell me if I'm right. Can I say equipment?
Sure.
Yes, because it's adequate under 9108, and 9504 says if it's adequate under 9108, it's adequate under 9504. Could you just say equipment?
Yes.
Yell it out. Yes! You can just say equipment. It's adequate in the financing statement, it's adequate in the security agreement. You can do it by type. So the problem here is they were narrowing it and then forgot to properly give the full description. And so now the question is, well, given the policy purposes of 9504 of the financing statement, is it okay? And I'm telling you, I can see a judge saying no, because they were dumb and didn't include the list. And I'll tell you, this happens more than you realize. It's not a common mistake. It's the kind of mistake I can see happening on a, not exceptional mistake. Somebody just forgets to attach the document. We good? Equipment would be good. All equipment would be good. Various pieces of equipment would probably be good. Various pieces of equipment as listed on attachment A, attached here too, no attachment? Probably not good. It's all in all the wording. All right, problem 39.
So in this one we have a security agreement that lists the collateral by category, and then the financing statement lists those categories, but then 2 additional categories. And so the parties are willing to testify that the 2 left out of the security agreement, but on the financing statement, are what they intended to be included in the security interest. And I said that I didn't think those 2 categories, inventory and accounts receivable, would be included in the security interest because they were left out of the security agreement.
Okay, so your answer is, sorry, you didn't list it in the security agreement, you're not covered. Can you make an argument the other way?
So I read the case and they talked about like parole evidence, and whatnot, but they said that no, that still doesn't work, so.
All right, but you're not making the argument. So make the argument. That case is wrong. We're not bound by it. You disagree. Tell me how you would argue that it should be.
Because it was the party's intention to.
Okay, first of all, contracts are about parties' intent. They didn't intend it. Is there a document that lists it?
The financing statement.
Okay, is anybody hurt by the security agreement not having it, but the financing statement having it?
I mean, the other creditors, potentially, if they look at the financing statement and see it's not in the security agreement and think, well, hey, I can get this
Yeah. What's the purpose of the security agreement?
to, bind the parties to the collateral.
It's a contract that creates a security interest, right? Did they create by contract a security interest in accounts and inventory? I think we stop, don't we? The debtor, the only hitch here is the debtor is willing to admit it was intended. I don't care. The statute's pretty clear on this. Under 9, and we're gonna talk about this in a minute, under 9203, you need a security agreement that describes the collateral. Do we have a security agreement that describes the collateral? No, right? Financing statement is broader than the security agreement. Security agreement is the document that creates the security interest. Is there a security interest? The court says no. Do you agree with that? So I'm curious, do you agree with the court?
If it's not in the security agreement.
The argument I think we would make is the composite document rule. We're gonna take all the documents together and they represent the intent of the parties. Okay, fair enough. Those rules exist. That's not what 9203 says. Yeah. Okay, next problem.
So here, OMB is wanting to, get security interest on Luddite Technologies, equipment. In particular, they want, the Abacus 12. And the question is just asking if they should say, in the security agreement that it is, asking, like, that they are taking out a security interest in all equipment or the Abacus 12 plus equipment. I kinda like borrowing from the language earlier of all equipment, including but not limited to the Abacus 12.
Is the statement all equipment adequate? Would it cover the Abacus 12? Assuming it falls into the category of equipment. If you say all equipment with the Abacus 12 included.
Well, it's a category, so I would say so.
Yeah, right? So why are you adding language?
Just cause, err on the side of safety, and I want that Abacus 12.
And this, I agree with that. I will caution you. When you start doing that and you make a mistake, the mistake usually ends up limiting yourself, right? The example of, it's on the list and you don't include the list. If you don't say it perfectly, you might lose all the other equipment. That's my one hesitation. So if you say all equipment, namely the Abacus 12, oops, it's just the Abacus 12. You gotta make sure you say all equipment, including without limitation, the Abacus 12. Or just say all equipment. My preference would be all equipment, because you can't mess that up. Just say equipment or all equipment. Perfect. But I think you're right. Going back to the earlier case, all equipment, including without limitation, the Abacus 12 works. But every time you start adding words, has anybody ever mistyped anything? Have you ever typed anything wrong on a piece of paper? Yeah. If we type stuff wrong on the financing statement, what happens? What happens when you don't include the list? You lose your security interest, or you lose your financing statement. That's the only counter consideration. Okay. The last one, let's see. Now we're talking about problem 41. Security agreement says interest to blank.
This one I was confused about because is his name, like, has he signed it apart from that, or because according to this Bollinger case, in order to make a valid security interest, you have to have a writing signed by a debtor describing the collateral.
Right.
And if it's signed apart from that blank where his name is missing, then I say.
Well, whose name is missing? Is it the debtor's name?
Yes.
No, it's the seller.
Oh, granting a security interest
So whose name is missing?
The secured party?
The secured party's name is missing. If there's no debtor's name, well, yeah, I think you're absolutely right. Forget it, there's no security interest. Maybe you could argue the signature line would count. Okay, there's a signature line, that's cool. But the law doesn't require the secured party to sign the security agreement. The law requires the debtor to sign it. So what if you have a security agreement, no named secured party? Is that still valid? Why?
The law doesn't require the secured party to sign the security agreement.
Does it require a name of a secured party? Does there have to be a secured party?
I'm gonna say yes, but I'm really guessing.
Okay, do you have to have a name on the finance? So first of all, which document are we talking about?
The security agreement.
Okay. Seller forgot that the seller later filed a financing statement showing that he had a security interest. Okay. There's no name on the security agreement, but there's a name on the financing statement. Is the security interest good? Yes. When the name is blank?
Yes.
Why?
Because
Who did they grant the security interest to?
Oh, no. I don't know, whoever is giving them a tractor.
Well, what does the document say? Who did they give a security interest to in the document?
No one.
Does a security interest exist that is blank? Don't you need a secured party?
Yes.
If you're the secured party, how do you get around this? What do you argue?
That you're making a contract so you know who the parties are?
The facts and circumstances surrounding the transaction, right? It's not like the debtor was tricked into signing this document. They knew who they were dealing with. I don't know, though. It feels really, if we're going to say a financing statement that says various but then doesn't include a list is no good, how can a document that doesn't include a named party be any good?
That's a security interest, though, or the security agreement that doesn't include the seller's name.
Right.
The financing statement does include the seller's name and the debtor's name, so it gives other creditors notice of this potential security interest on the collateral.
Absolutely right. Is
So
there a
the-
security interest?
Yes.
The financing statement is adequate. Is the security agreement adequate?
Yes.
Why?
Because it's the intent of both parties to enter into this security agreement, even though the seller's name is not listed on there. The debtor accepted whatever value the creditor gave. So I would argue that yes, the security agreement is enforceable.
Okay. Again, composite document rule, maybe we can say parole evidence is the intent of the parties. But did they sign a security agreement that named a secured party? 9203 requires that the debtor authenticate a security agreement that grants a security interest to the secured party. Did they sign a document that granted a security interest to anybody?
Well, as of right now, the facts do not, they're insufficient for that. It just says at the
Here's what I think would happen.
At the top.
Because I agree with this analysis. But if we understand where most of these cases are decided, did the debtor sign a security agreement that named a secured party? No, it's blank. You lose. Because I think it's a trustee in bankruptcy challenging the validity of the security agreement, and the bankruptcy court's gonna say, you need to sign the debtor. There's no in blank law, right? You don't sign things in blank. That's what I think the court would do with it. But I agree with your analysis. I think if we're arguing between two banks, nobody's confused, right? But if we're arguing trustee in bankruptcy against a bank, bankruptcy court says, didn't sign a security agreement that had a full description of everything that was going on. Sorry, it's blank. So I think there's a really good chance you lose this case.
So we flip this to financial statement, it doesn't matter then?
No, financing statement. Does it need the name of the secured party?
No.
Yes, it's actually in the law.
Correct.
9502. You have to name the secured party. If that's blank, you're clearly not perfected. The question here is, can you argue that the contract that created the security interest is adequate when there's a blank on it? If the secured party later signs down below, I think you're fine, right? It doesn't have to be in a particular place. But if there's no name of the secured party anywhere, and only the debtor has signed, it doesn't feel like you've signed a security agreement creating a security interest in the secured party. So I think there's at least a very good argument that a court would say no. And if I'm being hyper technical, I would say no. I would say this is an equity. All right, I think the bankruptcy court is willing to look past those kind of arguments, or not accept those kinds of arguments. Okay. Attachment. So we only have a few questions here that we have to talk about. We've done a lot with the documents. I want you to turn to page 94 of the book, and I want you to underline 3 words in the indented paragraphs. First paragraph, underline the word agreement. I think it's the first numbered paragraph. Second paragraph, underline the word value. Third paragraph, underline the word rights. Now, I'm normally going to say value rights agreement because that's the 9203. Why am I emphasizing this? I'm emphasizing this because that's when attachment occurs, value rights agreement. Debtor has rights in the collateral. The secured party has given value to the debtor, and there's a security agreement that grants the security interest in the collateral. Okay? You don't always have to have a written security agreement. It can be oral. We'll test that out a little bit later. But you have to have those 3 things, otherwise there's no attachment. Value rights agreement creates attachment. Security interest attaches when it's enforceable. It's enforceable when those 3 things have happened. And it's only enforceable when the last of those 3 things have happened. So let's take a look at question 42. I think we have enough time for at least 1 or 2 questions. So question 42.
Yep. So here we have Roy Gabriel. He goes into the music business and borrows $35,000 from Oculus National Bank. The question is, so with the $35,000, he's going to buy some trumpets and guitars and fiddle pipes. The question is, on what day or days did the bank's security interest attach? And I said it attaches on March 30th, the day that the equipment was shipped, pursuant to Statute 2501B, which states that the contract is for the sale of future goods other than those described in paragraph C when the goods are shipped, marked or otherwise designated by the seller as good, to which the contract refers.
So essentially, when under Article 2 sale, when the goods are identified to the sales contract, that's when the debtor has rights in the collateral. Is that what you're saying?
I'm saying they get the rights to the collateral at the day of shipment.
Yeah, that's the day that the seller has said, here, these are yours. Yeah, so they're identified to the contract on that day. Are they in the possession of the debtor on that day?
Yes. Well,
when does the debtor get possession?
So the debtor gets possession on the 30th. They shipped on the 15th.
Okay, so you're saying it's not until they get possession. So why did they actually get physical possession?
Yeah, so I think I should have said it's on the 15th. When they were shipped.
So 2501 says a buyer has rights in collateral a buyer has rights in the goods when the goods are identified to the contract, right? You're getting these trumpets. That happens on March 15th, right?
Yes.
So under Article 2, you have rights in the collateral. Under Article 9, is that enough to create a security interest? Is that rights sufficient?
Yes.
So that's the case, right? The previous case talks about when do you have rights in the collateral? And it's not ownership. It's not, you don't have to own the collateral to have rights in it. You just have to have some interest that the law recognizes. So in the case, it's like the guy's taking possession of the collateral and raising it, and then, raising it to birth calves. And the question is, well, are those rights in the collateral? And the court says, yes, we don't know what they are, but those are rights. So any rights. The seller says you're getting these trumpets. Does the debtor have rights in the collateral on the 15th? What does the security agreement say? When does the security interest attach? says,
I want to say on January 12th.
it says, the security grant, signs a security agreement giving ONB an interest in all existing after-acquired inventory in the store. On March 15th, are they in the store? Look at 9203A. When does the security interest attach? At the time that everything, it becomes enforceable, unless the parties agree to a later date, right? They can postpone the time of attachment. Here they said it's the stuff in the store. Are they in the store on March 15th? There's at least an argument that you have rights in the collateral, but you delayed attachment until they're in the store. That's a very hyper-technical reading of the contract.
He already has the guitars and the pitch pipe in the store.
All right, but here we're talking about the trumpets, right? So there are things in the store. So when is the security interest attached to the stuff in the store?
On January 6th.
So that's in the store on January 6th. Sign the security agreement. It says everything in the store, that's in the store, security interest attaches. Trumpets, is it when they're identified to the contract under Article 2? It says in the store in the security agreement. All right. We will finish up these last few problems next time and start perfection by possession and other methods of perfection other than final. So next week we're talking about how do you perfect, not by filing the financing statement, but by two other methods. Okay?
I gotta work that.
Did I send around the sign-in sheet? I did, right?
Oh yeah, you want to talk? Let's do it.
Are you leaving here with a sense of calm, with a sense of joy in connecting with the law?
No.
No? If you don't, please come talk to me. Send me an email. I don't do Facebook, so